found that Dr. Gauranga Kumar Phatak not only negligent in the conclusion they come to is Dr. Phatak is negligent in the pre as well as post-operative management of the patient, Mrs. Sadhu Khan, which led to her untimely death, etc. But he was trying removal of a doctor's name, ultimately, if illegal, ultimately does not serve any purpose, because it is the patients at the end do suffer because the doctor comes back after 2 years. So I submit, Millard, on the principles of prima facie case and balance of convenience. The writ petition may be heard out, but the order may be kept in abeyance for the time being. I am in this writ petition, Millard, I am challenging an order. I'm challenging an order passed by the appellate authority in an appeal from an order of the West Bengal Medical Council, which, Millard, has removed my name. I am a gynecologist by profession, which has removed my name from the rolls of the Medical Council on the ground of infamous conduct in my profession. Now, Millard, I have also challenged the vires of certain sections and rules, but for the purpose of interim order, I shall not address your lordship at all on that, because I know there is a presumption in favor of constitutionality. And Millard, I will not trouble your lordship with the facts of this case. I will not controvert them at this stage. I'll take the facts as they stand. I'll take the factual situation as alleged by them. My submission is that assume that I am a very bad person or a bad doctor, but even then I am entitled to due process. And in this case, Millard, due process and provisions of statutes have been violated at every stage, including principles of natural justice. Millard, kindly come first to the charge sheet, which is at page 83. It is dated 15th of January 2024.
Yes.
On behalf of the West Bengal Medical Council, I give you notice that information and evidence have been laid before the council, by which, on the basis of the complaint and further inquiry, the following charge has been made against you, namely, during the antenatal period of treatment of Miss Moumita Sadhu Khan, you did not make any psychiatric, neuromedicine, endocrinology referral, though you had noted the patient as that of psychoneurosis. You had performed an irrational LUCS on her on 28th of October 2019 in Megacity Nursing Home, while her EDD, expected date of delivery, was 21st of November 2019, and there was no proper indication of CS as the patient was not in labor. You had left the nursing home after the LUCS without leaving any official intimation to the nursing home authority and could come back late only to declare the patient dead. You had tried to mislead the Penal and Ethical Cases Committee of this council by claiming that you had handed over the charge of the patient to Dr. Arindam Mojumdar, which Dr. Mojumdar denied in writing before the committee. The autopsy report suggested that the patient died of massive internal bleeding, but there were no post-operative notes in the BHT, that is bedhead ticket, from 9:40 a.m. to 3 p.m., indicating total lack of post-operative monitoring, which could have diagnosed the situation and saved the patient, and that in relation thereto, you have been prima facie guilty of infamous conduct in a professional respect. And I am directed further to give you notice that a meeting of the West Bengal Medical Council will be held to consider the above-mentioned charges against you and decide whether or not they should direct that your name be removed from the register of registered practitioners pursuant to Section 1725 of the Bengal Medical Act 1914. Now, Millard, pausing here for a moment, Millard, here even the show cause notice shows a prejudgment and a closed mind, because, Millard, under Section 25 of the Bengal Medical Act 1914, the authorities have an option, the Medical Council has an option of either removing my name from the register or issuing a warning. So at the show cause notice stage, both the options are assumed to be open for the Medical Council depending on my defense. But, Millard, in the show cause itself, they rule out the warning part and go on the basis of the higher penalty, that is, Millard, removal of my name. Be that as it may, Millard, that is one of my submissions, Millard. Then, Millard, kindly come to the reply to this. The rest, Millard, is all procedural. Kindly come to page 85. I respond to the show cause notice. to the charge sheet rather. During the treatment of Srimati Maumita Sadhu Khan, I did not advise for psychiatric or neuromedicine or endocrine consultation because she was not having the said medical problem during this pregnancy. She was taking occasional psychiatric treatment before pregnancy, which was revealed during taking routine past history, as she was suffering from infertility and was receiving torture from the family. I would definitely ask for consultation of respective speciality if there would have symptom or sign of the disease. For example, on 25th of September 2019, I advised her to consult physician when she had fever. In my opinion, decision of LUCS on 29th October 2019, expected date of delivery such and such, was rational because this was pregnancy after treatment of infertility for 5 years, and the patient came to my chamber on 28th October 2019 with complaint of dribbling per vagina, which she was carrying 37 weeks pregnancy. So she was admitted and kept under observation. Next day morning, dribbling increased and she was in early labor. So considering valuable pregnancy, LUCS was done. I left the nursing home as usual, like other routine cases, long after shifting the patient to the ward, throwing the patient to her husband, and talking among themselves in good condition. I did not make any official confirmation because I was not leaving the station. And I went to see my old mother to a house only 30-40 minutes distance and keeping the communication open over mobile. For any emergency, I could attend the patient in time. In fact, this much time might be required if I would start a hysterectomy operation after this LUCS operation. Definitely, I would make official information if I would leave the station for long distance. I did not neglect the patient because I kept all communication open, and when I got information from nursing home, I immediately sent a qualified, experienced anesthetist who informed me that the patient is quite well and no need for me to go to the nursing home at that time, and he noted the stable condition of the patient in the bedded ticket. In fact, I rushed to the nursing home quickly around 4:15 p.m. when I got the information again that the patient is complaining of chest pain. I informed the ward RMO to shift the patient to ICU. I started treatment along with ICU RMO and ward RMO and other doctors who were present there at that time. Meanwhile, I consulted with her husband also in ICU. This is wrong information that I reached there after the patient is dead. I have never tried to mislead the Penal and Ethical Cases Committee because myself and Dr. Arindam Mojumdar, Gynae, do group practice in Barashat. Whenever any patient of us needed any help, we communicated each other by phone and we attend the patient. In this case, I went to see my mother, which is not so far, with telephonic information that if needed, he will attend the patient. Afterwards, I did not inform him as the anesthetist informed me that the patient is stable. During the second incident, I was at station and myself attended the patient. Dr. Arindam Mojumdar is right to say to the committee that he does not know about the patient. I think that the patient was properly attended because after completion of the operation, I was in the nursing home for above 1 hour more and I checked the patient before leaving the nursing home. I did not make any note in bedhead ticket because the patient was all right. After that, the patient was taken care by the on-duty nursing staff and ward RMO time to time as per my instruction. That's why they could communicate me when the BP of the patient became low. There was no note in the bedhead ticket during the period from 9:40 a.m. to 3 p.m. because there was no problem of the patient during that period. When the problem arose, it was noted in BHT at 3 p.m. The patient was cared time to time. That's why nursing home could communicate me and I sent one qualified and experienced doctor to see the patient immediately who found that the patient is stable. The stable condition of the patient is also confirmed by the complainant, Mr. Sanjay Sadhu Khan, which is evident by his statement in his complaint letter to the Registrar West Bengal Medical Council that at 3 p.m. he saw the patient quite normal and so he refused to shift the patient to ICU. After that, he was sitting beside his wife as it was visiting time, during which time patient complained chest pain when RMO immediately attended the patient and patient was shifted to ICU. I think if you would allow the patient to shift to ICU earlier, there would be better monitoring. I think failure of diagnosis is not negligence. I am working in this capacity for the last 40 years with good reputation and sincerity wherever I have worked. Further, I am to inform that I operated the patient in West Nursing Home at Barashat, having good nurses, both ward RMO and ICU RMO and all sorts of critical care facilities at ICU. The team of the operation is good. I have 40 years experience, etc. Millard, this is my defense. Now, Millard, kindly come to the order passed by the West Bengal Medical Council after this. dated 13th May 2024 at page 88. Millard, a cryptic, unreasoned order. It says, sirs, this is to inform you that the West Bengal Medical Council at its extraordinary meeting held on 9th of May 2024, after considering the charges as framed up, vide this office notice of inquiry dated 15th January 2024, which I have already placed, as was communicated to you for hearing of the charges, found you guilty of infamous conduct in a professional respect, and decided that the name of Dr. Gauranga Kumar Ghatak, registration number such and such, be removed from the Registrar of Registered Medical Practitioners maintained by the West Bengal Medical Council for a period of 2 years from the date of communication of the order in this respect under Section 25A2 of the Bengal Medical Act 1914, and your name has accordingly been removed from the register from the date of communication of this order. Your attention is being drawn to the provisions under Section 26, which reads as under which I can prefer an appeal, which I did. Now, Millard, there cannot be a more unreasoned order than this in respect of such a serious penalty that my name as a medical practitioner is being removed from the rolls of the council. There is no discussion. Now, Millard, the whatever transpired in the alleged extraordinary meeting held on 9th of May 2024 is not disclosed to me at all. And that is being referred to. And Millard, I would say an ipse dixit on the part of the respondents, a one-line communication that your name has been removed. No discussion on what act would constitute infamous conduct on my part, because there is a huge body of case law on what would constitute infamous conduct, and the courts have said that even mere negligence will not constitute infamous conduct.
Yes.
Now, Millard, I prefer an appeal against this order to the Principal Secretary, which is at page 89. I will not trouble your lordship with my appeal petition. Kindly come to page 91, which is the order of the appellate authority, being the Principal Secretary, on an appeal preferred under Section 26 of the Bengal Medical Act. This is an appeal under Section 26 of the Bengal Medical
Please don't read the whole thing, because it appears to be a detailed one.
I will not kindly, Millard, take a portion of it. Kindly come, first of all, to, because, Millard, the initial paragraphs, in fact, almost the whole of the order only records what various committees have said. But even then, kindly come to page 93, capital A, because this is important for my purpose. Internal page 6 of the order.
Yes.
In view of the above observations, the Penal and Ethical Case Committee 5 found that Dr. Gauranga Kumar Ghatak not only negligent in the conclusion they come to is Dr. Ghatak is negligent in the pre as well as post-operative management of the patient, Mrs. Sadhu Khan, which led to her untimely death, etc. But he was trying to mislead the committee. Now, Millard, this finding of negligence is not compatible in law with a finding of infamous conduct. And I am covered by authorities, I can come to this narration of history goes on. So I will not trouble your lordship with that. Kindly come, Millard, after it ends at page 95, capital A, or Millard, page 96. In fact, come to page 96. Up to small Roman 1, it is merely narration of what earlier committees had said. But I wish to make one comment that these reports of the Penal and Ethical Case Committee, experts, etc., were never communicated to me, even when even after passing of the order. This, in fact, that is already there. In this respect, kindly come to page 97. Millard, it was only on 29th of May 2024 on my request that my request made in 17th of May 2024, they responded by furnishing the opinion of the expert committee. Then, Millard, the others, they say that P&D committee is already part of the deposition, so they are not furnishing it separately. But this comes 29th of May 2024, much later. So, Millard, they are relying on expert committees, P&D committee, etc., without Millard supplying these materials to me at all and without affording me an opportunity of rebutting that. Now, Millard, kindly come to, after they end this narration, kindly come to page 96. The only portion which seems to be their order. The postmortem report suggests death was due to the effect of postpartum hemorrhage, antemortem in nature. It is evident from the evidence of Sri Dibbendra Ghosh of Megacity Nursing Home Private Limited, taken on 25th July 20, paragraph 34, 34 and 35. I am reading 35. It is evident from the evidence of Sri Dibbendra Ghosh of Megacity Nursing Home Private Limited, taken on 25th of July 2023, that the appellant Dr. Ghotak left the nursing home in the morning around 10:30 a.m. The evidence of Dr. Arindam Majumdar clearly suggests that the anesthetist attended and supportive treatment was given to the patient and the patient was shifted to ICU around 4 p.m. to 5 p.m. Then, the next sentence is very significant in a matter of this nature. So, in all probabilities, the appellant Dr. Ghotak was not present at the nursing home after 10:30 a.m. till the patient shifted to ICU at 5 or 5:10 a.m. Therefore, first of all, I have clearly indicated that I arrived much before she was shifted to the ICU and I treated her in the ICU. But even apart from that, they themselves say that in all probabilities. So the order of removing me, or rather confirming the order of my removal, is based on a probability. The evidence of Sri Dibbendra Ghosh of Megacity Nursing Home suggests that there was no official intimation regarding his leaving the nursing home, and on the other hand, intimation was given to Mr. Ghotak time to time, Dr. Ghotak time to time from the end of the nursing home, but Dr. Ghotak did not visit the patient before shifting her to ICU. The appellant herein or his assistant, Dr. Devashish Ghotak, MBBS DGO, did not come to the nursing home to see the patient in spite of several intimations by the RMO in a period of about 6 hours in the immediate post-operative period, which was clearly professional medical misconduct. In law, I join the issue here because the law is that even assuming there is negligence, there is no infamous conduct, which is tantamount to misconduct. If the present appellant would have been present at the nursing home at the very first call, then the so-called postmortem massive internal hemorrhage could have been managed and untimely death of a young mother could have been saved. Then, my defense is not discussed at all. Paragraph 37, they only say the submissions made by the appellant in support of his innocence have got no leg to stand upon. In view of the evidence on record, post-mortem examination, report, observations of the experts, and therefore the appeal fails. Accordingly, the present appeal is hereby dismissed. I assail this order on the ground of not disclosing any reasons at all for affirming the order of the West Bengal Medical Council, and relying on materials not supplied to me. And even the appellate authority constituted an expert committee whose report was never made available to me, apart from the question that it's my submission that the appellate authority has no jurisdiction under the Act to form an expert committee at the appellate stage. Now, the non-application of mine is further evident from para 39. Consequently, the ordered decision impugned passed by the West Bengal Medical Council dated 13th of May 2024. This is not the fact, The order is dated 9th of May 2024, communicated on 13th, because they say that the decision was taken on the 9th in the extraordinary meeting of the West Bengal Medical Council for removal of name of Dr. Gauranga Kumar Ghotak, having registration number 36043 of WMC, from the Register of Registered Medical Practitioners maintained by the West Bengal Medical Council for a period of 2 years from the date of communication of that order under Section 25A2 of the Bengal Medical Act 1914. I submit therefore, that both the orders, the West Bengal Medical Council order and more the appellate order, suffers from violations of the principles of natural justice because materials relied upon not supplied to me. Secondly, both the orders in my humble submission are devoid of any reason. Thirdly, assuming there is a finding of negligence, which the appellate authority records as part of the findings of the P&EV committee, negligence does not and cannot amount to infamous conduct in the profession as contemplated. And there I am covered by authorities. If your lordship wants, I shall cite those judgments.
But not today, at least,
Not at
because
the motion stage. That's why I'm
cannot
feeling
be
a little
done.
diffident.
Hmm.
Millard, in the circumstances, I am praying, Millard, that the order may be kept. In fact, I'll also rely on a judgment of this honorable court in a bench presided over by Justice Mukherjee, of which your lordship was also a member, and your lordship delivered a separate concurring judgment, but not today. Millard, in the circumstances, I am praying that this order of removing me may be kept in abeyance, because, Millard, if ultimately the writ petition fails, I can serve out the rest of the order, and my name can stand deleted for the full period of 2 years. That can be made up. And in that judgment of the division bench, your lordship has been pleased to observe that removal of a doctor's name ultimately, if illegal, ultimately does not serve any purpose, because it is the patients at the end do suffer, because the doctor comes back after 2 years. So I submit, Millard, on the principles of prima facie case and balance of convenience, the writ petition may be heard out, but the order may be kept in abeyance for the time being.
So for the-
And Millard,
Anybody for the state?
It is meeting, my lord, on the last occasion, your lordship directed to serve a copy of this petition.
Yes, that is for the purpose of the challenging the virus. That
I'm
apart.
not addressing the
Yes, he has not addressed, but then the appellate order by the principal secretary is under challenge. So the state is required to be
we have served
represented.
everybody.
So for the
And Millard, before my learned friend begins, I missed out a point. I'm grateful to my learned junior, which may also my case, that the West Bengal Medical Council, I've stated so in paragraph 26, on the day on which they called me, did not have the quorum at all to hold the meeting. There were 5 members present, whereas the prescribed quorum is 7. Those are my subjects.